the Court of Appeals decision in Cahill versus Triborough Bridge and Tunnel Authority in 2004, which is 1992. And as you recall, you may recall, they were working on the bridge. The guy had to use a safety harness to get up, and it's a pain. You have to unattach and go, oh, so the guy's not using it. And he falls, and that's the end of him. And he was instructed to do this, to use the lanyard properly, weeks before. Court said that's enough, so you don't need an immediate instruction. The reason I brought up the Smith case and Gordon, Stolt, Hagens, and Jastrabisky is, I'm telling you something. There's a lot of appellate division cases that are coming down now in 2007, 2008, that aren't even citing Cahill. I think Cahill they're viewing as an aberration. I think we're going to hear from the Court of Appeals and get a clarification on it. They're going back and citing cases like Stolt, like Hagens, like Harris versus Rodriguez. And take a look, for instance, at page 95, Fitzsimmons versus City of New York, which didn't even cite Cahill. Take a look at page 98, Landsgraf, a First Department 2005 case. And interestingly, here's a Second Department case, 2007 at page 100, Santo versus Cerro. The court cites Jastrabisky, the old rule. Direct, immediate order not to use a device required. Available safety devices have to be in place at the workstation, because you see, Cahill never overruled any of those cases, as Blake never specifically overruled Hames. So that's why sometimes it's very hard for any of us to understand what's going on. So I predict within the next year, and as we know, the court's changing, we're going to have some clarification on the Cahill rule, because it's not really being consistently followed. You could take a look at also at McCarthy versus Turner at page 100. So here, let me conclude, because I've over my 5 minutes, and you can see Howard's a lot bigger than me, and he takes advantage of that. The pendulum swang, it was in 78, probably unfair. Plaintiffs were, summary judgment. Carrie's got to pay. And it swung with Blake and Montgomery and Cahill way over. So now we're seeing a lot of cases getting tossed on summary judgment or questions of fact, and a jury tossing the cases. Now it's starting to swing back, and I think what we're going to find over the next year or two is it's going to reach a middle ground, and hopefully a middle ground where both plaintiffs and defendants will be able to look at a case, evaluate it, and make a decision based upon some solid law, and not have these cases all over the place. That's what I anticipate, and I hope for all of those who return next year, if we have this program, and I know in Howard we probably will, we'll be able to talk about that. But I would say this, as in summing up, don't take Cahill as Hornbook law. It's not being followed consistently. More often than not, it's not. Blake, you take seriously, and you go in there as a defendant, and you ask, how tall was that stool? You find out. If you're a defendant, you go right into your client. Let me see the stool. Let me measure it. Let me stand on it. Let me have my expert stand on it. Could I reach the window? And then you question and you prepare your defendant witness to testify. Yes, the stool would have been a proper safety device. Yes, it was available. Yes, we told her there. And we all know that these maintenance people know these stools are in the closets. We all here in New York work in office buildings. We know how the maintenance crews work. You show that and you win the case, okay? So I'd say as defendants, you really have to take these depositions much, much more seriously than you used to. And as plaintiffs, you better do it also, because you have to understand that in every one of these cases, any defendant's attorney who practices in this area is going to be looking to see if they can knock you out on a sole proximate cause or recalcitrant worker defense. I wish I had more time. I'm going to hang around all day. I have a whole bunch of cases with me. Anyone wants to discuss any of them, have any questions, disagreements, be glad to speak with you. Thank you very much.